Good afternoon to all. MLNG Societies, Manikchand Pahadi Law College organized 1 week online lecture series on Code of Criminal Procedure, Juvenile Justice Care and Protection Act, and Probation of Offenders Act. This is our third lecture on the analysis of concept of plea bargaining in the context of Code of Criminal Procedure. Today we have Dr. Nital S. Nandedkar Madam, who is the in-charge principal of VN Patil Law College. Madam has completed BSL, LLM, NET, PhD in law from Swami Ramananda Tirtha Marathwada University, Nanded. She is working as in-charge principal from 2017 in VN Patil Law College. She attended more than 20 international, national, state and regional level seminar conferences and workshops on different subjects of law. She published various research papers in international and national repute journals on the topic of cybercrime, cyberspace, environmental protections, human rights, constitutional law, women empowerment, etc. She also worked as editor of various books and journals. She attended various courses in laws. She also delivered various lectures as a resource person in the seminar and conferences on the different topic. She has more than 12 years of teaching experience for PG and UG level. She also worked on various administrative bodies of Dr. Babasaheb Ambedkar Marathwada University, Aurangabad, different colleges and the different universities. With these few words, I welcome Dr. Nital Nandedkar ma'am and I request her to please kindly guide us on the topic. Over to you, ma'am.
Thank you so much, sir. Good afternoon, one and all. First of all, I would like to thank MLJ Societies, Manikchand Pahade Law College, respected Principal Dr. C.M. Rao sir, Dr. Chauhan sir, and all teaching staff of MP Law College for inviting me in this lecture series on Criminal Procedure Code. Sir, shall I share my slide?
Madam, please, you can share. It is visible, madam, no problem.
So now my topic of seminar is analysis of concept of plea bargaining in context with Criminal Procedure Code. Before going towards this topic, we have to understand what exactly bargaining means. Bargain, that word we used in our day-to-day life. How we use this word? See, if we want to bargain, what we do? Just by simple example, I am going to explain you. We entered into market, we want to purchase something. If we want to purchase anything, we have decided to purchase it. If, for example, it is of 5,000 rupees, but we want it in 3,000 rupees because we think that that is of that worth only. What we do? Then we go over there and give offer to that seller, that give that particular sale, that particular thing, particular goods for 5,000. Instead of 5,000 rupees, you sell me 3,000 rupees. So here what we do? We have already started bargaining over there. Bargaining regarding what? Bargaining regarding price of goods. So that is called bargaining. Now here we are talking about plea bargaining. So here in this case, we are going to see what exactly plea of particular individual. Particular individual means an accused person. He is going to make certain kinds of statement. He is going to make certain kinds of contentions before court, and then on the basis of that contention, court is going to bargain the same. That is called plea bargaining. So that concept is there. This concept is actually concept which is introduced for the healthy court system over there, and for the for particular thing. So next point, what we have to discuss in this presentation is that I have given over here. First one is meaning and concept of plea bargaining. Second one is historical background of plea bargaining on national and international level. Then Malimat Committee report, position of this concept of plea bargaining before amendment. Next one is object of plea bargaining. Then types of plea bargaining. Then next one is provisions under CRPC from section 265A to section 265L. Next one is benefit in respect of victim and accused. Thereafter, we are going to discuss about advantages and disadvantages of this plea bargaining. Afterward, we are going to discuss about recent trade judicial pronouncement regarding this concept of plea bargaining, and finally we conclude this session with conclusion. Now, one by one, I am going to explain you what exactly this concept of plea bargaining means. See, this concept of plea bargaining is actually shows its significance to one famous saying, that is justice delayed is justice denied. How it relates with this saying. See, justice delayed means if there is any case, if accused file any case for trial before court, or sorry, victim is there, if he filed any case for justice before court of law, for trial before court of law, he is victim over there. What he want from court of law, what he want from judiciary, he want quick justice, fast disposal of case. But if case is pending for 3 years, 5 years, 6 years, what it amounts to delay. Once it is delayed, it going to frustrate the person who filed suit, who filed case, who want justice from court of law. That's why once justice delayed over there, it going to be denied. Here in this case, this concept of plea bargaining is going to give certain kind of relief to that kind of person, instant relief out of filing of case, out of that kind of things which happened with him. So here in this case, that is so related that justice delayed is justice denied. So justice delayed is just and justice denied is relates to a plea bargaining. Plea bargaining is going to give fast disposal of case, fast relief to the person who is victim of that particular thing, or who is victim of that particular act. Next thing is related to this concept is that it is going to show alternative remedy to a long and tortuous trial of court, which has been introduced. Why this trial has been introduced? It has been already introduced in criminal justice system for speedy disposal of cases and to reduce the overburdened prisons. Now next thing here is that what exactly this meaning of this plea bargaining. See, the meaning of this bargaining, we can define that it is a pre-negotiation between accused and prosecution, where accused is agreed to plead a guilt, and in exchange of that, what he want? In exchange of that, he gets certain concession from sentence, concession from charges, and concession from certain kinds of fact and circumstances regarding that case. So here in this case, he gets certain kind of benefit. So that is called pre-bargaining. It is one kind of negotiation. Next, we can define it that it is a bargain where defendant or accused pleaded guilt for lesser of the charges, for reduce of the charges, and what prosecutor has do over here. The prosecutor in return or court in return drop more serious charges which has been already levied against that accused person. So this is actually the meaning of this concept of plea bargaining. Now next point is here that reasons and object, that why we introduce this concept of plea bargaining or provision of this plea bargaining under our criminal procedure code. There are certain reasons and object. First one is to reduce the pendency of litigation. Obviously, the basic object behind introduction of this concept is to reduce pendency of litigation. There are so many pendency of litigation. We are all are aware about the court system. We all are aware about the pendency of litigation, and that is not entertained by the court because they don't have that much time, or this is very time consuming process is there. That's why pendency is there. Now, next one is decrease the number of under trial prisoner. See, this is very important point is that under trial prisoners are there in India. We all remember one case in our constitution we have already studied, that is Husainara Khatun versus Union of India. That particular case is specifically related with under trial prisoners. Compensation awarded by our honorable apex court in that case also. So under trial prisoners are there, it is going to decrease under trial prisoners. Means if under trial prisoners not attended by court, trial is not come before the court, in that sense, if the prisoners, that kind of prisoners are ready to make plea bargain, to bargain their sentence, to make plea before court of law, to make application before court of law, if they ready to make application before court of law, submit application regarding plea bargain, then automatically it going to reduce reduce the number of prisoners those are there as under trial prisoners in court of in that prisons. So third point is related to make provisions of compensation. As we all know that being a law student, being belongs to a legal fraternity, generally this compensation is there in civil cases. For example, uncodified law is there, that is law of tort, where specifically mentioned about compensation, that how much compensation has to be awarded, that is in the form of liquidated, that is in the form of unliquidated. So here in this case, compensation provision has to be inserted, though it relates to criminal case, but compensation has to be awarded out of this concept, out of this provision of plea bargaining that has mentioned over here. So victim can get certain benefit also out of this plea bargaining, out of this provision of plea bargaining. Now next and last point is regarding saving legal expenses of both the parties. As we all know that our Indian judicial system is very expensive one. So if a person don't have that much financial capacity to bear all these things, to do all these things in a court of law, whatever required for trial. So here in this case, it's saving expenses of both the parties, means accused as well as victim. If accused is there, obviously he has to engage some pleader to plead his case, and if victim is there, he can do same for the trial and everything. So it is going to reduce the expenses, it save the expenses. So that is very beneficial, means this concept is very beneficial for both the parties. Now next thing is regarding history and origin of this concept of plea bargaining. So before all these things, we have to take look towards international perspective of this concept of plea bargaining. Actually, this concept of plea bargaining was firstly introduced in American legal history. Then thereafter, it is re-emerged. This concept re-emerged after Second World War, when there was a crime wave. So many crime committed at that time, and that's why after Second World War there were wave of, that is crime wave, and afterward they think that there is requirement to settle down these disputes through settle down this crime through plea bargaining, through certain kinds of, or we can say that mutual understanding, to settle down the dispute, to settle down the crime by mutual understanding. So here in this case, this concept of plea bargaining is used in American judicial system in 19th century. Thereafter, in 1969, one incident was there. To avoid execution, James Ray pleaded guilt. For what he pleaded the guilt? For assassinating of Martin Luther King. But it was rejected and he get 99 years of imprisonment. Again, in case of Brady versus United States, where it was stated that the court has specifically mentioned, the Supreme Court of United States has specifically stated that if anything out of this concept of plea bargaining, provision of plea bargaining, if any benefit is there to an accused person, automatically in turn that benefit extend to state. What the state get relief, it is going to reduce overburdened prison, it is going to dispose of the matter, automatically number of pendency going to be reduced. So that kind of benefit is given to state. In turn what they have given to an accused, they are going to reduce the punishment of accused, and in that return, for that return, state gets something. So that is not unconstitutional. This thing has specifically mentioned over here in this case of Brady versus United States. Now, furthermore, 1 year later, in Santobella versus New York, the Supreme Court, the United States Supreme Court, has specifically accepted that plea bargaining is essential for administration of justice and it should be encouraged. Once it is encouraged, it is going to be useful for administration of criminal justice system. Now, next thing is history and origin of this concept in India. There are so many law commissions report before introduction, before incorporation of this concept of plea bargaining in criminal judicial system in India. One by one, we are going to study this. First one is Law Commission report. 142nd Law Commission report has specifically mentioned that how it is useful. It is given one kind of outline to the concept of plea bargaining by saying that it is useful for under trial prisoners actually. Under trial prisoners means which kind of a prisoners? Those are there which is yet not tried by court. If the person committed theft, punishment is 3 years imprisonment. But from 7 years, if he is in jail, then what is the use of this particular trial if he is not yet produced before court of law? So that's why that is called under trial prisoners. Hence, this report has specifically mentioned that it is useful for under trial prisoner and submits its report. Then next is regarding 144th report. That is the first recommendation made in this report regarding introduction of plea bargaining. They are not only support regarding the provision of that it is helpful for pre-trial prisoners, but it has also mentioned that this is going to reduce the delay, whatever delay is there regarding entertainment of the cases, regarding trial of the cases in court of law. So it is going to reduce the burden on the prisons, as well as it is going to reduce the number of cases those are yet not tried by court due to constraint of time. They don't have that much time to entertain the suit or trial. Lastly, in 177th report, which is produced in 2001, and in that report, it has specifically mentioned to incorporate the concept of this plea bargaining, to incorporate this concept of plea bargaining in criminal judicial system of India. Afterward, what happened? After this all law commission's report, NDA government decided, finally they have formed one committee, and that committee headed by former Chief Justice of Karnataka High Court and Kerala High Court, that is Justice V.S. Malimath, and Malimath committee is going to form to make recommendation regarding introduction of this concept of plea bargaining. Finally, in 12th Law Commission report, it is going to support the recommendation made by Malimath Committee regarding incorporation of this concept of plea bargaining in criminal justice system of India. Next step towards incorporation of this plea bargaining, that is in 2003. After Malimath Committee recommendation, this concept of plea bargaining introduced in criminal justice system by Criminal Law Amendment Bill 2003. That was not enough for us. Next, what we do in 2005, again by making slight changes in the recommendation of committee, we introduced, that is Criminal Law Amendment Bill 2005. And finally, it effect in July 2006, we have incorporated it under Criminal Procedure Code 1973 with Chapter 21A and Section 265A to 265L. So this journey is not so easy for us to incorporate it, that is this concept of plea bargaining, which is going to compromise the matter, which is of criminal nature, and we are going to compromise it. So that journey is not easy for us. Before completion of this journey, there were so many steps. See, prior to this amendment, I have also mentioned what we faced. Our Indian judiciary has been reluctant to apply this concept prior to 2005 amendment, but still every time whatever the opinion passed by, whatever judgment or adjudication is there regarding this concept, that all were negative. First, here I am going to give you one example, and I have also mentioned one case, which is that is Mandan Lal Ramchandar Daga versus State of Maharashtra. Here, in this case, in the opinion of court has specifically stated that it is very wrong for the court to enter into a plea bargaining for such kind of offenses which is of more grave in nature. So it is wrong for the court to enter into a plea bargaining. If court is going to show leniency towards such kind of offenses on accused, then it will affect on the sentence of imprisonment. Here in this case, remark negative things passed by honorable court regarding plea bargaining. So they are not going to accept such kind of bargaining in certain cases, in certain grave offenses. Next, here in this case, next is Kasam Bhai Ardul Rahman Bhai Sheikh versus State of Gujarat. In that case also, court observed that it would be against the public policy to give conviction to an accused by inducing him for plea of guilt. Firstly, to induce him for plea of guilt, and then thereafter, why he make plea of guilt? They stated that by inducing him to plea of guilt, and then thereafter that person, he that certain kind of benefit out of this given to that person. If the court is saying that induce him to make plea of guilt, and out of that you get certain kind of benefit, which kind of benefit? That your punishment is going to be reduced. This thing is unreasonable one. It is unfair, unjust, and violation of Article 21 of Indian Constitution. It has specifically it has specifically stated over here. So in next case is same that have mentioned by our honorable Supreme Court, that Kachia Patel Shantilal Koderlal versus State of Gujarat. It has also mentioned the same thing, that plea bargaining is unconstitutional, it is illegal one, and it is going to encourage corruption also. Next, in case of state of UP versus Chandrika, that is 2000, before amendment in criminal justice system 2005, Apex Court, Honorable Apex Court has rightly held that mere acceptance of plea of guilt is not ground to reduce the sentence, or he just going to plea a guilt. That is not the base, that is not the point to reduce sentence or to lesser the punishment. This is not, we cannot say like that, ki yes, now he accepted plea of guilt, we are going to reduce his sentence. Now he make admission of guilt, we are going to reduce the sentence. So court is not going to accept this actual concept of plea bargaining. So here actually the previous stage of our amendment and previous situation what we faced before amendment under under the criminal procedure code, and then thereafter we are going to study about which kinds of plea bargaining are there. As I have already told you that plea means any kind of contention which is produced through an application by an accused person for bargaining. But there are different kinds of bargaining in different countries. What we followed in India, there are three kinds or three types of bargaining. That is, first one is charge bargaining, second one is fact bargaining, and third one is sentence bargaining. So what exactly charge bargaining? It also bifurcate into two parts: multiple charge and unique charge. Unique charge is one only, and multiple charge means there are so many charges filed or levied against an accused person. So here in this case, some charges are dropped by prosecution, some charges dropped by prosecution or court in turn of plea of bargaining. If a person ready to plead guilt and ready, he filed application for plea bargaining, then whatever serious charges are there, they are going to reduce that kind of a charges, and what are lesser charges are there, they are going to give punishment for that kind of charges. No, it means that going to drop serious kind of charges. Next is unique charges. A serious charge is dropped in exchange of plea bargaining, and then thereafter only one single charge is there. Then instead of giving that kind of charge, that charge is going to drop down and lesser punishment is going to be awarded if he is ready to plead guilt. Next one is fact bargain. This is very interesting one. On the basis of factual aspect, all aspect known to prosecution, all aspects known to court, factual aspect, all aspect known to courts as well as to the prosecution. Now here in this case, fact produced by an accused before the prosecution. Now what prosecution going to decide? Prosecution is going to decide that whatever aggravated charges are there, whatever aggravated factual aspect of that case, he is not going to reveal that thing in court of law. Whatever serious factual aspect is there, he is not going to produce it before court of law, reveal it before court of law. Instead of that, he is going to produce the selective factual aspect before court of law so as to reduce the punishment. That is agreement between accused and prosecution, that is bargaining, that is plea bargaining, that is plea bargaining on the basis of fact, on the basis of factual aspect of particular case, not on the basis of charges, not on the basis of sentence. Now next one, this factual aspect and actually this charge bargaining is based on one legal idiom which is followed in America, that is nolo contender. So nolo contender here it means that I wish I wish to accept, but I do not want to contend. Means here it that I am going to sanction, I am going to give sanction for plea bargaining, but I am not going to contend it. Mm, I am not going to accept the guilt, but I am ready for plea bargaining. So this is called charge bargaining and fact bargaining. Now last one is that is sentence bargaining. Bargaining is actually accepted practiced in Indian judiciary. Our Indian judiciary is going to support this kind of practice, that is sentence bargaining. Sentence word we have already used, 3 years sentence of imprisonment, 5 years sentence of imprisonment. Here it means that term of imprisonment. If term of imprisonment is 5 years, then it is going to be reduced 3 years, 2 years. That is called bargain on the basis of sentence. If the person is ready to plead guilt, then court is ready by mutual satisfactory disposal, decide all the things, compromise all the things, decide the compensation, and then thereafter they are going to reduce that kind of sentence in particular case or whatever the charges are there against accused person. Next point is we are going to turn towards procedural aspect which has already mentioned under criminal procedure code. So here in this case, as I have already told you, it is came into force in 5th of July 2006 by amendment under Criminal Procedure Code 2005, that is Criminal Law Amendment Act, and it has been inserted under chapter 21A from section 265A to 265L. One by one, we are going to study the section. One by one, we are going to study the provisional aspect of this concept of plea bargaining, how it converted into provisions. Before that, we are going to see applicability of this plea bargaining, on whom this plea bargaining, provision of plea bargaining is going to be applicable. First point, it is clear that where the punishment is less than 7 years, if for any offense, if punishment is less than 7 years or up to 7 years, less than 7 years or up to 7 years, in that case only this provision of plea bargaining is going to be applicable. Now next thing is related to this plea bargaining provision is going to be excluded that kind of offenses where the punishment is of life imprisonment, imprisonment for death, or any kind of imprisonment which exceeds 7 years, which is more than 7 years, then in that case also this concept of plea bargaining, this provision of plea bargaining is not going to be applied. Next, in case of women and children, women and child less than 14 years of age, if they are not of 14 years of age, this concept is, this provision is not going to be applicable. Now next we are going to study about first section, that is section 265A, application of this chapter, where this provision is applicable and under what circumstances it is applicable. When the court is going to take cognizance of this case, first thing is that court is going to take cognizance in two sense, in two ways. First one, when it is recorded or when it is instituted on police or police report, and second one is when the case is instituted on complaint. So first thing is when the court take cognizance, when it is instituted on police report under section 173, that is related to investigation. When investigation officer submits application for plea bargaining, what it should contain? See, that application which is produced in a court of law regarding offense, it has specifically mentioned under this section that that offense should not be punished with life imprisonment, death imprisonment, or any imprisonment which is more than 7 years. So which kind of offense is going to be entertained? Where the punishment is less than 7 years, then the court can take cognizance under the provision of 265A. Next one is when the case is, when the application is on complaint. If the complaint process means due process has been followed, the court on the basis of that complaint issue process under section 200 and section 204 of CRPC, then also court going to entertain. But the same case, a same rule is there, same provision is there, that offense should be punishable, means that offense should not be punishable with life imprisonment, death imprisonment, or punishment more than 7 years. So that thing is there under section 265. So where it applicable and on what offense it is going to be applicable. Next one is section 265B. Section 265B is regarding application of plea bargaining. Here on a slide I have mentioned step by step, that is provisions and as well as clauses of section 265B regarding application of plea bargaining. So here in this case, the application of that plea bargaining, first accused person has to make an application before court of law for plea bargaining. After making an application, as we all know that we have already studied, if we want to make any kind of application, for example, if we want to file plaint in court of law, what kind of content are required in plaint, that have mentioned under CPC. Here same thing is there. If accused want to make any kind of application before court of law regarding plea bargaining, what kind of contentions are required, what content are required, so that we can say that yes, it is application of plea bargaining. So first thing he has to mention over there, brief things, brief description regarding offense, which kind of offense he has committed over here. Next one is acceptance, his voluntarily acceptance regarding plea of guilt. He voluntarily accept and he is voluntarily ready to enter into plea of guilt, and at what extent the punishment is provided for that offense. He was also, he should aware about all these things also while making an application. Offense is of what nature, what punishment is provided over here, and next thing is regarding he is submitting this application voluntarily, and afterward he has to submit this application with affidavit, his own affidavit, that he was aware, he is aware about all these things, about all these application. And next point regarding this section 65, 265B clause 2, which is relates that he should not previously convicted. If he is previously convicted, then that application is going to be rejected by court. Here, the content of application is required if you want to make application for plea bargaining. Now, next one is, after all this process, after making application, what is the role of court? Now, court is going to issue notice to the public prosecutor, to the complainant. If the case is registered, if the case is instituted on police report, then court is going to issue notice to public prosecutor. If case is instituted on complaint, then complainant. That's why in section it has specifically mentioned that court going to issue notice to public prosecutor or complainant and accused person also. After issuing notice, now what next step, that is court has to be taken here in this case. Court is going to examine accused. After giving notice, the court call public prosecutor or complainant and accused, and in length on a fixed date court is going to examine accused person. He is going to examine accused person for what? He want to take, or he want to observe that whatever application made by accused person, that is voluntarily one with his own consent, he should ready for plea bargain. So to check all these things, for satisfactory disposal of case, the court is going to inspect that accused, but subject to condition that that accused should be inspected by court by magistrate in camera. Other party should not allowed over there, because court want to check that whether this application filed by accused is voluntary one with his own consent. That's why opposite party is not required over there. So camera proceeding is mentioned in this provision. Next, clause 4 is that clause 4 is bifurcated into two parts, that is clause 4 subclause A and clause 4 subclause B. So what clause 4 stated that, clause 4 specifically I have mentioned that camera proceeding is required, camera proceeding of accused examination is required. 4A, clause 4A stated that the magistrate should provide time after examining the accused, magistrate should provide time for mutually satisfactory disposition of this case. Court has fixed time, fixed date, and then thereafter court has issued notice to whom? To the public prosecutor or the complainant, and then thereafter to an accused as well as victim. But before fixing this date of mutual satisfactory disposition, court specifically mentioned that on what point they have to work out. They have to work out regarding compensation of victim, and then thereafter plea bargaining. So plea bargaining and compensation has to be mentioned over there in that kinds of satisfactory mutual satisfactory disposition. Now clause B, that is subclause B of clause 4. It is stated that if in any case that application is involuntary, if court found that consent is not there, application filed by accused that is involuntary one, then what court has to do? Here in this case, court has to stop over there the concept, the provision of plea bargaining, and it returned to that stage from where that case started, from where the trial started, where the trial was there at the time of making of application. So where the accused was there when the application was made by an accused, from that stage court is going to try the suit regular manner without considering plea bargaining. If he found that any involuntary thing is there, the accused is not ready, his consent is not there for proceeded with concept of plea bargaining, provision of plea bargaining, then he again started normal trial. So this is actually section 265B. Now next one is section 265C. This section is regarding guidelines for mutual satisfactory disposal. It's very simple one. It has also mentioned certain kinds of guidelines for satisfactory disposal of this case. Which kind of guidelines? As I have already told you that there are two parts. When the case is instituted on police report, and when the case is instituted otherwise than on police report, means on complaint. So when case is instituted on police report, the court is going to issue notice to whom? Court is going to issue notice first to the public prosecutor, second one to the investigation officer, because case is instituted on police report. So investigation officer is required, public prosecutor, investigation officer, accused and victim to participate in meeting of mutual satisfactory disposal. Then thereafter it provides that, next it is provided under this clause that throughout under that procedure, throughout under this meeting, it is duty of the court that it is duty of the court that all process should be voluntary one. It should be completed voluntarily. Every party should agree for that satisfactory disposal. Then and then only it is going to be worked. Next, it is provided that if provided that the accused may, if he so desire, he can enter into meeting with his own advocate, with his own legal representative. So he can participate in meeting with his own legal representative. Next point is next related to otherwise than on police report. If it is otherwise than on police report, if it is on complaint, then court is going to issue notice to whom? In this case, court is going to issue notice to the victim and accused only. They are come together for mutual satisfactory disposal of this case. Here in this case, same provided clause is that the court always take precaution that it should be voluntary one. Each and every party should enter into meeting with their own consent. So no force is there, no undue influence is there. And next one is that is in this case also accused can enter into meeting with his own legal representative. So here we have a section 265C. Now next one is section 265D regarding report of mutual satisfactory disposition to be submitted before court. To be submitted before court, when it is going to be submitted, and when mutual satisfactory report is completed, it is produced before court of law, then it should be signed by presiding officer. And if no such mutual satisfactory disposition is there, if no satisfactory disposal is there, no disposition is there, court found that it is not going to be work out over here regarding this provision of plea bargaining, then whatever I previously said, the same thing from where the trial is begin, it is going to be begin from that stage only. So court is going to try the suit in a regular manner if the mutual satisfactory disposition is not there. Next point here in this particular next section is regarding disposal of cases. So how this case is going to be disposed of under section 265E. So under 265E, first and foremost important thing is that award of compensation to the victim. So court first observed before disposing the case under plea bargaining, under the concept of plea bargaining, what kind of compensation paid to victim. If the court satisfied with that mutual satisfactory disposal, compensation is awarded, then on the basis of compensation and quantum, by deciding quantum of punishment, court can release accused on probation of good conduct. Even court can release accused after admonition, which has been mentioned under section 360 of Criminal Procedure Code, or any other law which provide that kind of relief to an accused. Court going to impose it that kind of punishment, or court is going to release that person if such kind of provision is there in any other law. Next thing is related to this section only, that is section 265E, that is clause B, which has mentioned that the on probation also court is of the view that it he can release that person on probation also, so he can release accused on probation. Next one is after hearing both the parties, court find that if there is any kind of minimum punishment, if minimum punishment is provided for that offense, then how much punishment has to be passed, how much terms of imprisonment has to be passed by magistrate. Here in this case, if minimum punishment is provided, then out of that minimum punishment, half punishment has to be provided. See, remember this rule. If minimum punishment is provided, if minimum punishment is of 3 years, then half of that 3 years, 1.5 year has to be provided, has to be passed by magistrate. Second point is that, second clause means D clause is that if minimum punishment is not there, then in that case, whatever punishment is there, out of that, one-fourth punishment has to be given to that accused. One-fourth punishment awarded to that accused. So this is two kinds of rule which we have to remember regarding this mutual satisfactory disposal in case of provision of plea bargaining. Minimum punishment is there, then half punishment court is going to be awarded. If minimum punishment is not there, then whatever punishment is there, out of that punishment, one-fourth punishment has to be awarded by court or magistrate. Next point here in this case is related to judgment of the court. It's very simple one. Which kind of judgment means? Judgment passed by the court in that is mentioned that if the court is going to deliver the judgment, it should deliver that judgment in open court only. And it should be signed by presiding officer. So this clause is very simple one. It has also mentioned under your CRPC, that is sessions trial, court session trial. It has also mentioned that court should pronounce the judgment in open court only. So same clause is here. Now next one is, that is section 265G, that is finality of judgment. Finality of judgment means here in this case, this judgment is final one. It is not going to be appealed. So it is that clause has specifically mentioned and used the word that is a mandatory one. No appeal is there, so it is final. But it has also mentioned one sentence, except. Except means when special leave petition filed before the Supreme Court under Article 136 and before High Court under 226 and 227. In that situation, it can be through writ, we can challenge it. So judgment is going to be final. No appeal is there, but you can file special leave petition and challenge it. You can file writ petition also before the High Court and regarding this judgment or against the judgment passed by magistrate. Now next thing is regarding section 265H, power of the court in plea bargaining. So which kind of power is there to the court? Court is having each and every power whatever he exercised in other cases. What he exercised, whatever power vested with court, that is bail, trial of the offenses, recording of the witnesses, all things are there while disposing the matter. So same power, the court which is going to exercise this provision, these provisions of plea bargaining under CRPC, that court is having same power to entertain the case. It is not going to change any kind of power. So now next one is next related to section 265I. It is period of detention undergone by accused to be set off. Period of detention undergone by accused to be set off against the sentence of imprisonment. Whatever sentence, see, we from first point of this presentation, we are going to talk about under trial prisoners. So this under trial prisoners means that kind of prisoners which are still in prison. If they are in prison for more than 7 years, more than 6 years or 3 years, for example, if punishment is there for 3 years, he is already there from 3 years. If for that offense punishment is 3 years, he is there from 3 years, then what is use of that kind of trial? Afterward, when punishment is pronounced, he has already undergone this period. He has already ended that period over here. So 3 years imprisonment and he has already there for 3 years, that is no use. Whatever period, if he is there for 6 months and punishment is awarded under plea bargaining, that is for 1 year. So that 6 months which he has already undergone in prison, that is going to be set off. Means only 6 months is remain and he can only there in prison for remaining 6 months. That is actually the provision going to be set off the punishment, sentence of imprisonment. That is period of detention undergone by accused which he has already undergone, that is going to be set off, and the sentence which is passed by magistrate. So if 1 year sentence is there, he is from 6 months over there, so remaining 6 months is going, he has to undergo on for remaining 6 months. The 6 months period is going to be set off. So this is actually provision under that section. Next one is saving. Saving clause is there, that whatever the provision, that is section 265J, it mentioned that whatever provisions are there of this particular chapter, it is not going to constrain the other provision of CRPC. It is not going to cause any kind for sorry, what I mean to say, if any provision is there which is going to contradict this provision, so this provision is became as it is over here, or it can be applied to other cases also regarding this provision. So this provision is not going to constrain inconsistent with any other provision of this act. Now, explanation clause regarding public prosecutor, what it mentioned, that what is the definition of public prosecutor, that has already defined under section 25 of CRPC. So, whatever punishment mentioned under CRPC regarding public prosecutor, the same thing is applicable over here when we are talking about public prosecutor. So, court is going to issue notice to public prosecutor. So, call public prosecutor for mutual satisfactory disposition of the case. So, public prosecutor here, it means that the same public prosecutor which has already mentioned under CRPC. Now, next one is section 265K regarding statement of accused not to be used. See, as I have already told you, whatever statement made by accused, here plea of guilt is there, he is going to pleaded the guilt, and plea bargain is there. So on the basis of that plea of guilt, see, both the things are different one, plea bargain and plead of guilt, that is both the things are different one. But here in this case, if he pleaded the guilt, if I am ready to accept, but on the basis of going to plea bargain, you are going to bargain my sentence, that's why I am going to pleaded the guilt. So if he pleaded the guilt, that statement is not going to be used in further proceeding. That kind of limitation is there. Why this limitation is there? See, if the statement is going to be used in further proceeding, it can be misused. It can be used like confession, because he is going to make plea of guilt over here. That's why this limitation mentioned under section 265K, that specifically said that whatever statement made by an accused for plea of guilt under this provision, it is not going to be used in any case. It is not going to be used in any further proceeding. Next one is that non-application of this chapter. This chapter and this particular provision is last one. So this chapter is not at all applicable to Juvenile Justice, Care and Protection of Children's Act. Now we are going to come to a last points of this particular presentation. That is, what kind of benefit out of this provision given to the victim. See, it's very easy one. Firstly, it is going to give compensation to the victim. Obviously, victim gets something in the form of compensation out of this mutual satisfactory disposal. Next one is, it is less time and money consuming process. Here in this case, victim is not going to expend his money, or victim don't want to expend his money regarding this, so it is going to save all these things. Next one is, he can save himself from long, tortuous or long trial of criminal trial before court of law. Next thing is that what kind of benefit is there to an accused person out of this provision. First one is, it is going to minimize the punishment, so he will get half of punishment. If minimum punishment is there, he will get half punishment. If no minimum punishment is there, then whatever punishment is there, out of that he will get 1/4 punishment. And afterward, he can get also certain kind of benefit. He get the period set off procedure is there. He can set off his remaining imprisonment, whatever he undergone over there in a prison. And afterward, more than that, he can also get benefit of probation, admonition, here in this case under that provision. Next one is no appeal is there once the judgment pronounced by the court, that is final one. Once it is final, it is not appealable in any court. Next next benefit is that whatever admission he made over there, that is not going to be used in any case further, in any proceeding further. It's limit to plea bargaining, it's limits to this provision only. And obviously whatever thing is there that is less time and money consuming, it is same for victim and it is same for accused also. So time saving is there. Now next one is advantage of this provision of plea bargaining. First one, it manage cases load over the judiciary, manage the load of cases over the judiciary. Next one, reduce workload of the prosecutor. That's why prosecutor can give its more time to serious kind of offenses, serious kind of trial. So whatever trials are there, those are of 3 years, 2 years, that is if going to be satisfied, going to be compromised under this provision, then automatically it is going to save time of prosecution also. So no time and money consuming trial. Accused just submit his application before court of law, and now court going to work on concept of plea bargaining or provision of plea bargaining. Next one is prosecution find chance to get plea of guilt out of this particular provision of plea bargaining. Under provision of plea bargaining, he can get the particular kind of particular statement from an accused regarding plea of guilt, and he aware about this plea of guilt. So if his case is weak over there, prosecution case is weak over there, then he can get certain kind of benefit. But as I have already told you, the statement is not at all going to be used in further proceeding. Next one is it given relief to victim, and given relief to victim in the form of compensation and out of long criminal trial. Next thing is related to disadvantages. So there are also three kinds of disadvantages I have mentioned. First one is for the accused, there is every chance of practically coerced, means on the basis of a statement, court or prosecution is going to told him, a defense lawyer going to told him that if you pleaded the guilt, you are going to or court is going to reduce the charges. Some kind of coercive state treatment uh, is to be happened against accused. Next one is that is plea of negotiation is substantially more likely than a trial to result the conviction of innocent. So most cases, as we all know that what is the rate of conviction and what is the rate of acquittal in Indian judicial system. 80% of cases turn into acquittal. So if the person is going to be acquitted, if he is having hope of acquittal, then why he is going to enter into such kind of procedural aspect of plea bargaining? So if most of the time there is a chance that if he pleaded for plea bargaining, then he is going to be convicted. So in that case, there may be possibility that innocent is going to be convicted. Last one is it shows leniency towards offender. Obviously, court is going to show leniency towards offender in that case. Next one is recent judicial trend of plea bargaining. I am going to sum up it with 2 or 3 minutes. That is, two cases are there regarding recent judicial trend of this provision of plea bargaining. In case of state of Gujarat versus Natwar Thakur, what the court says that this concept of plea bargaining is very healthy for criminal justice system. It is one kind of a step towards judicial reform. Furthermore, in this case, court has specifically stated and emphasized on one saying is that that every person should remember that every saint, means the person who is of moral character, saint, we can also call him sant. So here in this case, every saint has his past and every sinner has his future. So every saint has his past and then he became saint, and every sinner means every accused is also having his future. So for his future, we can use it. We can use this provision of plea bargaining. Now next case is Sakharam Bandekar's case in 2007. This case is related to corruption. Corruption charges were there against accused, and on the basis of that he was of 58 years of age. Due to that age, due to old age, he want to excuse from the court and he filed application for plea bargain. But court stated that corruption is a serious disease like cancer, and that's why the case of corruption, charges of corruption is not going to be, it is not going to entertain under this provision of plea bargaining, or it is not going to be compromised under this provision. So this is actually recent trend of plea bargaining. Now last point, I am going to turn towards conclusion of my session. That is, I want to conclude my session here by saying that plea bargaining is one kind of prescription to the problem of overcrowded jail and overburdened court. Second one is that if the proper training provided to the judicial members legal fraternity regarding introduction of this provision of plea bargaining, we are going to solve issues, we are going to solve the issues related to criminal trial, and we are going to give relief to more and more victims those are suffering from these kinds of lengthy and tortuous trial of court. Last one, I want to conclude that there are so many advantage and disadvantage of every concept, but we have to try to improve each and everything, and it can be improved by practice only. So here in this case, I have concluded my session and I have complete my topic related to analysis of concept of plea bargaining in context with criminal procedure code. Finally, I would like to thank MP Law College as well as respected principal and all teaching and non-teaching staff of MP Law College for inviting me in such nice lecture series of criminal procedure. Thank you so much, sir.
Thank you, madam, for a thoughtful lecture. We have two questions, and the question is raised by Ravi Kiran Shukre, and these two questions are related with each other. The first question, I think it is already answered by you. What he asking the question arise in his mind regarding the principle of plea bargaining, as it is a violation of Article 20, subclause 3 of the Indian Constitution. No person accused of any offense shall be compelled to be a witness against himself. Madam, you want to put something?
Article 20, clause C of Indian Constitution, it is not going to violate this principle of plea bargaining here, because it has already mentioned under section, that is 265. It has mentioned under their clauses that statement is not going to used anywhere, and you are not going to compel anyone. Every time I have already explained in provision that court is going to take precaution that it should be voluntary one. It should be voluntary one. If it is not voluntary, it is involuntary, then court is going to start from where he has left the stage of trial. So here in this case, court is not going to compel anyone. So here the case is different one, plea bargaining is different one. See the student, plea bargaining is different one and plea of guilt is different one. That's why I have given example of that legal idiom nolo contender. Nolo contender means I do accept but I don't want to contend. I am going to give sanction but I am not going to contend anything. So don't mix it. In the case, last case, that is case of Gujarat, that is state of Gujarat versus Natwar Thakur. If you read that case in length, the judiciary means apex court, our honorable apex court has specifically bifurcated these things, that don't mix up plea bargaining and plea of guilt. Both the concepts are very different. So here we are not going to compel anything, and that's why we are not going to violate. Means this provision is not going to violate Article 20, Clause C of Indian Constitution.
Okay, madam, there is a second question, whether this section 265K indirectly point towards the section 133 of Indian Evidence Act?
Which section, sir?
Whether the section 265K indirectly point towards the section 133 of Indian Evidence Act.
133 of Indian Evidence Act.
Yes.
And section 265K.
K of CRPC.
No, sir. Not it is not going to show any kind of direct relevance with section 133 of Law of Evidence Act, and statement of accused to be not to be used. Here it means that we are not talking about law of evidence here. See, 133 is not going to show any relevance over here, that is admissibility of statement in court of law. What we say that it is one kind of compromise, and that compromise is related to criminal case. That's why this clause is mentioned over here. Whatever statement made by that person, that is not going to show any relevancy in subsequent proceeding.
Okay, thank you, ma'am. Dear participant, there is a small announcement for you. Tomorrow we have Dr. V.G. Ranganathan with us. He will deliver a lecture on the trial procedure before the criminal court. With this informative lecture, on behalf of management, staff, and student, and on behalf of all the attendees, I am very thankful to Dr. Nitin Nandedkar ma'am, and I am also thankful to all the participants. I am also thankful to Dr. C.M. Rao sir, the principal of MP Law College, and the all teaching and non-teaching staff for their continuous support. With this, I conclude this session. Thank you very much, one and all.
Tomorrow lecture details.
Sir, tomorrow there will be a lecture of Dr. V.G. Ranganathan sir on the trial procedure before criminal court at the same time. I will share the link on the WhatsApp group.
Thank you, sir.